Bueno, pues llegamos ya prácticamente al final de este tercer panel del seminario. A lo largo de la mañana de hoy hemos visto cómo los ponentes nos han expuesto la magnitud del problema en torno a las obras huérfanas. También hemos visto los distintos modelos y soluciones existentes y que de hecho ya aplican varios estados para afrontar el marco de protección de las obras huérfanas. Y ahora, una vez que se nos ha expuesto esta situación, no podíamos dejar de culminar el debate en torno a las obras huérfanas sin tener en cuenta la importantísima y esencial experiencia y punto de vista de la Comisión Europea, no solo por las iniciativas que va a lanzar y que está lanzando actualmente en este ámbito, por sus competencias en esta materia, sino también por la dimensión europea que tiene y que da en este seminario de presidencia española del Consejo de la Unión Europea. ¿Quién mejor entonces que Tilman Luder, del que obviamente doy por hecho que no necesita presentación porque ustedes de sobra le conocen por su profundo conocimiento en materia de derechos de autor? Así, haciendo un breve resumen, como saben, es jefe de la Unidad de Derechos de Autor de la Comisión Europea y es el responsable del desarrollo de la política de la Unión Europea en el área de los derechos de autor y derechos relacionados. Él ha impulsado, como saben, diversos estudios de impacto, propuestas legislativas, informes de evaluación, la administración de 7 directivas y la representación regular de la Comisión en los diversos grupos de trabajo relacionadas con esta materia. A nivel internacional es enormemente conocido y representa a la Comunidad Europea y a sus Estados miembros como representante de la Comisión en esta materia en la Organización Mundial de Propiedad Intelectual. Es un honor presentarle y le doy a continuación la palabra. Muchas gracias.
Gracias por su introducción. En primer lugar, quiero dar las gracias a los organizadores, al gobierno español, a la biblioteca, para tener esta conferencia muy interesante y muy oportuna en este tiempo. Voy a continuar en inglés porque no voy a molestar todo el mundo con mis primeros pasos en la lengua española. ¿Es muy bien? Yeah, you like it? Okay. Well, okay. And the next council working group, I will do Spanish then, or maybe in the next WIPO meeting we'll just switch to Spanish as a practice ground. Now the rest of it is so dull as night. As Shakespeare would say, that I can only do it in English because it's so technical. But I'm trying to make it as lively as possible, also to show that we have invested quite a bit of time and work into first understanding the scope of the orphan works issue, and then also the possible approaches to this, especially from the viewpoint of a regional organization where any kind of orphan works identification and orphan works display in a digital library, of course, has a dimension which goes beyond the territory in which the orphan work has been identified. First of all, as Maria Palante said, in the United States, the Google Books settlement brought legislative efforts to a grinding halt, in the sense that it superseded legislation with the new opt-out model. And I'm happy to say that in the European Union, it was actually the opposite. Google triggered the legislator to even take note of the orphan work issue. And I still remember in 2006 when the US Copyright Office presented its first study on orphan works, and I listened to this and I said, wow, this is a really arcane issue. I don't know why they're doing this. It's just amazing. I didn't know about orphan works as such. And it never came to the fore in the European Union until there was the Google Books settlement and until there was this widespread outcry. What are they doing here? They're doing an opt-out when there should be prior authorization. And then suddenly I think the European Union woke up to the fact that if you have a large-scale digitization project, it's really easy to operate such a project on the basis of an opt-out, because there are millions of right holders involved, and there are millions of rights to be cleared for the online display at least. The prior digitization is usually in the European system covered by exceptions for preservation. But for the public display, you need a form of authorization. And suddenly everybody realized, well, Google is actually taking the easy way out here. They're first digitizing, and then they're asking the questions later. And we criticized this, and certainly some of our member states even submitted amicus curiae briefs. But obviously then we got the question back like a boomerang. Okay, if you don't like the system of opt-out, if you want to have a system of prior authorization, what can you actually offer as an alternative in the European Union? Because you just can't go on and criticize Google and saying they're doing it the wrong way without proposing something positive. And that was actually a wake-up call and a very positive event for us, because that triggered us into serious considerations of what we would do. The other consideration was, of course, that out of the 10 million books that Google has digitized in the United States, taken from libraries in the United States, 1.5 million are allegedly in the public domain. That leaves us with 8.5 million, which are still protected by copyright. And we got estimates that between 2.5 and 4 million of those were actually works of European language origin, works presumably written by European authors. That would mean that if the settlement is approved, about 40% of the works covered by the settlement would actually originate from countries of the European Union. That again triggered the consideration that if these works were then displayed online in the United States under an opt-out system, the service that Google provides, as the class action settlement only applies to the United States territory, would be limited to the United States, which in turn means that more European origin works would be accessible in an online library at US universities and to the public at large, if these services were adopted, than to the Europeans. And that brought us to the consideration that if European scholars wanted to work and research on the basis of certain topics in a digital library, they'd actually have to go to the United States to do so, to find European origin material. And that was also seen as a bit of a wake-up call, that if the digital library takes off in the United States, then obviously the whole research corpus will go to the US library, to the US universities who have these academic subscriptions, and the research is conducted there. So these were the two elements. We were criticizing opt-out, so we had to come up with a better solution. And we were seeing that a massive digital library was created in the US on the basis of a mass usage of European origin works, which were not even accessible to the public at large in Europe, and certainly also not to the university. What do we do? Some people suggested that we should have a Google Book settlement in the European Union, and that the Commission should facilitate a Google Book settlement in the European Union. But again, that might have been based on the principle of opt-out. Most people advocated in these circumstances that we would legislate, and we would legislate in order to create a framework that we would have European digital libraries which were in compliance with the principle of prior authorization. The advantage of the legislative approach, most of our stakeholders argued, was that this legislative approach would ensure that not just one beneficiary can digitize the cultural heritage, but a multitude of beneficiaries could get authorizations to use orphan works, because, of course, a legislation applies erga omnes, amongst all participants. So several initiatives could exist and compete or exist alongside. So the advantage, of course, of a general legislative approach is that it creates a level playing field for everybody who wants to engage in digital libraries. Coming to the legislative approach, we identified essentially 6 options. 3 options based on non-licensing approaches, and 3 options based on licensing. Now, the licensing, of course, was the much more difficult to describe and to understand, so I shall start with the licensing options. Most of them have been mentioned in the different panel interventions up to now, so I don't need to go into details what it all means, but there was certainly one option was the extended collective licensing scheme as practiced in the Nordic countries. The second option was a specific licensing scheme that would only cover orphan works. And the third option was what is customarily referred to as the so-called Canadian and also now in Europe as the Hungarian model. That means that a public authority determines the orphan status. In Canada, the public authority also grants the license. In Hungary, as we have seen this morning, it is delegated to a collecting society. Now, before going into the options, there were some basic parameters which most stakeholders advised us to take into consideration. First of all, under all the options, the argument was a diligent search should precede the online display. That means, to be very concrete, that we had a problem with the extended collective licensing scheme. Because the extended collective licensing scheme in many ways resembles the Google Books settlement. And this is not actually something negative, it is just that the system is practically the same. In the extended licensing scheme, as we heard, you are covered as the owner of an orphan work if you belong to a category of right holders, and this category has a collecting society which has a representative membership. Now compare that to the Google settlement. You're in the settlement if you didn't opt out, and the Google Books registry will license your works, and post-display will actually do an effort to locate the parents of the orphans. That structurally is very similar to the extended collective licensing system, where you're in the license. It's not called settlement, it's the license. And there is no diligent search prior to the public online display, but the licensing body will do a diligent effort to, subsequent to the display, locate the right holder. Some people have argued we should actually do to the US as they have done unto us and adopt the extended collective licensing system as a European model, because then we would do exactly what Google has done to the European works in the US, to the US works in Europe. That was very elegant, because we mentioned in one of our submissions also to the Council of Ministers, which is the European representatives of the member states. We did a report on the settlement, and there is one hidden phrase in there which nobody actually took up, and because of that I shall have to read it to you. The settlement, we say when we talk about the repercussions on European right holders, the settlement potentially raises issues of international comity. In this particular case, the question arises whether comparable settlement agreements that may be concluded in other jurisdictions may restrict protection granted to US works and US right holders in line with the reduction of protection that the book settlement entails for non-US works in the US. I think that under international comity we could have argued, okay, we'll do the same, we'll do a European-wide extended collective licensing system. Everybody is in, unless they opt out. Sounds familiar. And once the licensor body has granted a license, they will do a reasonable search, a diligent search to find the right holders. We didn't ultimately, I think it's yet to be determined what we're going to do, but we didn't yet endorse such a system. We didn't endorse such a system because most stakeholders argued that the diligent search has to come up front. The diligent search has to come prior to the online display. This is why the second licensing option then presented itself, where we had a system where a diligent search is done in the country of first publication. The result of this diligent search is then made publicly available in an online registry. This result is recognized in all the other member states of the European Union as being sufficiently diligent. And then a rights management body in the country where the diligent search has been authorized will grant a license. And as this rights management body takes, for the limited period when the author is not locatable, ownership, this rights management body becomes, if you like, the foster parent. But as this rights management body now has an entrustment of the ownership interest in the orphan work, this rights management body can license across Europe. It's not limited to its national territory, because this rights management body is the stand-in owner. And as you know, all territorial restrictions in the European system result from the fact that the mandates are based on reciprocal arrangements, and the reciprocal arrangements are concluded in bilateral agreements with territorial restrictions, because the society says to its right holders, I represent you in my territory, and in outside territories I conclude reciprocal arrangements. So therefore it's territorial. Now, if a particular society is the foster parent, it has ownership, so it can license across the European Union. It doesn't need to do territorial restrictions. The disadvantage of that approach is something which we've seen in the music licensing sector as well. A library initiative would have to take out a variety of such orphan work licenses depending on where the orphan work was first published. That's the so-called repertoire-specific license. So let's assume that in France a diligent search has been carried out. It is recognized as an orphan work in France, thereby it's recognized in all the other member states. The French rights management organization can now give a license for display to the French National Library, which is valid for the whole European Union. But if the National Library of another member state, Spain, wants to digitize the same works, it has to get a license from France. If it wants to digitize and display works from Italy, it has to get a license from Italy as well for the works that were identified first in Italy. That's in general how the system would work. So there is a bundle of licenses to cover all the works that were identified after a diligent search in the relevant jurisdictions. And then there was the third licensing model, which was based on the Hungarian system, whereby the state identifies the orphan status. So it's a public body that identifies the orphan status. And the option would be that then the local society licenses these orphans, or the state licenses the orphans. Certainly, when we analyzed it, when we looked at the state licenses, we came up against the territorial restrictions, because both the Canadian and the Hungarian system are, of course, limited to displays that occur in Canada or Hungary. The state has no licensing power beyond its national borders. In these circumstances, we got a lot of submissions also in hearings from the European Parliament. So in these circumstances, of course, the parliamentarians started to plead for an exception. And they sort of packaged this plea rather diligently, I must say. They didn't say that under the exception, we would be dispensed with a diligent search, and we would be dispensed with indemnifying reappearing right holders, but they crafted in their proposals and in the different hearings where this was presented, the exception in very narrow terms. The argument was that the exception would only apply after a diligent search has been carried out in a country of first publication. Again, the diligent search would be recognized in the other countries as being sufficiently diligent, because the country of first publication in whose language the work was published would obviously be best placed to carry out this search and would be the most diligent entity to do so. And then, after the orphan status has been recognized, there would be publication of this status, but then any library, museum or archive could use the orphan for non-commercial display uses across Europe, because every member state would have a narrowly crafted exception only for non-commercial uses by a set of beneficiaries which were predefined and which were basically derived from the existing exception that applies to reproduction. Libraries, archives, museums. They were institutions that act in the public interest, and they would make it available for non-commercial use. And then there was a system of redress added, that obviously the user would have to keep funds in blocked accounts in order to indemnify reappearing right holders. So I have to say that those who proposed the exceptions did propose an exception which looked rather attractive, because there would be a diligent search and there would be indemnification for reappearing right holders, and obviously the orphan work status would end as soon as the owner of the orphan work reappeared and made a credible claim to ownership. Nevertheless, at this stage, the exception is not in a front runner, let me say, because there are issues of principle. There are issues that orphan works, contrary to what we've heard, it's difficult to deal with them as abandoned property. They were not specifically abandoned. It was just that at this stage you cannot locate the owner. I should also like to say that the problem really arises for us when we want to create a European response to the Google Books settlement in relation to printed and published material. Obviously, we are aware of private diaries and archives, but the principal focus at the moment here is on printed material and on books, and in these instances, we normally can identify the author. It is just that this person or his heirs cannot be located. So in that sense, dealing with this just as abandoned property under an exception seemed to be a bit radical, to put it rather bluntly. Of course, then we had the do-nothing option, which in a sense is the option pursued up to now, for the reasons that I stated at the beginning. It is to leave it to the member states to legislate on orphan works and to trust that they somehow will overcome the territorial limitations of the national approaches that they've chosen, to issue recommendations, as our colleagues in the Information Society did, and to trust that this will sort out the problem. What our colleagues in the Information Society department have told us repeatedly is that the mere soft law approach that was also mentioned this morning ultimately would not resolve the problem, because there is no positive obligations on member states to actually legislate on orphan works, to actually have a system of diligent search in place, and possibly a legal scheme that covers the online display. So as long as member states are not obliged, we'll have a high percentage of member states who will just do nothing about it, and then there would be no determination of orphan work status for all the works that were published, for instance, in those territories. So that brings me to this option number 6, which is an hybrid option, which is obviously the compromise option, which is taking elements of all the option and putting it in a big bundle. and it sounds attractive, and it is attractive, and it has certain advantages, but I cannot hide from you that it also has certain pitfalls. So let's be honest about the mutual recognition option. The mutual recognition option takes the element of all the licensing options. So I misspoke. I already gave the extended collective licensing system an element of diligent search. It takes the elements of the two other licensing options, but possibly this element could be added to an extended collective licensing scheme. It requires that there is a diligent search. It avoids duplication of diligent searches in the different jurisdiction by determining the jurisdiction in which the diligent search has to take place, which is the country of first publication. It then requires that member states have a system of redress for reappearing right holders. And it leaves to the member states how they organize the online display. The member states can have national approaches to how they would authorize their respective national library or other libraries in their territories, how to organize the online display. And the territorial limitations of the national approaches would be overcome by the good old principle of mutual recognition that we know in European legislation from many other fields, notably, of course, as you all know, product standard and foodstuffs. If they are legally produced in one member state, if there is no imperative requirement of health and safety, they shall be legally marketable in the other member states as well. And what is it here? If the orphan work status has been determined in the country of first publication, and if the country of first publication has organized under the system of its choice that the library can display this, and if they have a system of redress in place, this is recognized in all the other member states as legal, and therefore you don't need to block access to the website of the particular national libraries. The advantage is obvious. It leaves discretion to the member states to organize the precise modalities under which you can upload, as long as the upload is preceded by the diligent search. The second advantage is also rather obvious, as the mutual recognition would be in a framework community so-called directive, which is a kind of a framework law in the community. There would be now, for the first time, a legal obligation of the member states to actually legislate in the area of orphan works. So it would not just be a recommendation that it would be a nice idea to do so, but there would be a binding legal obligation within a deadline to be fixed in the Community Act to adopt legislation on the orphan works, covering the two essential elements, which is recognition of the orphan states and system of redress in case of reappearing right holders. If all member states then had systems, they would have to adhere, as we heard this morning, to a set of common guidelines on what diligence is. Then those systems could be mutually recognized amongst member states. And then we would have the free access to all digital library websites across the EU. These are the advantages. I shall point out the pitfall, because in an impact assessment you have to be rigorously honest and you can't just sort of hide what is the issue or what potential problem might be. The potential problem might be that systems chosen will be complex. Second issue is that there might not be immediate disagreement amongst the different jurisdictions what the acceptable threshold of diligence is, although I think that's a lesser problem because as the country of first publication is the one who carries out a diligent search, I can see rare instances where other countries would contest that the country of first publication was not sufficiently diligent. The problems is in the upload, in the integration of the work in a digital library. We would rely in this respect on national systems, as long as there is redress, and we would possibly create an unequal situation or time differences in the upload if some national jurisdictions choose for systems which are complicated to negotiate. So that's one pitfall. If there is disagreement amongst the stakeholders in one member state about the conditions of the upload, if some of the licensing issues lead to disagreement on the applicable tariffs, if some of the tariffs are deemed by the respective libraries to be of such a nature that the whole project is not functioning, or if they argue, for instance, libraries will possibly argue, there's already a cost in the digitization itself if the tariff isn't adapted to the actual use of the orphan work. Then we just simply cannot afford this. So these are the things that under a mutual recognition system would have to be sorted out. The licensing actually has to function. It has to function within a time frame which would still make this attractive. So let me conclude where I started, which is that this is a response also to show that we can have a European approach. We don't need the opt-out system in Google. We of course hope, and this is an appeal also to the representatives of the member states assembled here, that we can adopt a framework rule on the basis that possibly of mutual recognition within a time frame which makes the whole project interesting for all of us here. That means a relatively fast legislative procedure and a relatively swift implementation. Because we are still in a competitive relationship with our friends in the US. They're still negotiating the Google Books settlement, and if this Google Books settlement in some form is approved, they might still steal the march on us in the sense that the Google Books library will display 40% of European works only in the US. I've said last week in New York that I hope that it will take the settlement parties in the United States a very long time still to negotiate. I'm thankful to the government that they put up additional roadblocks along the way. You're helping us a lot here. We obviously want to have a chance. We obviously want to prove that the legislator can compete with these private party arrangements, that if a legislator bundles his energy and if we focus on the issue and if we don't get lost in side issues, then we could actually compete with a system where the private parties make the law amongst themselves. But if we, of course, legislate here now for 5 years and then have endless implementation, then people will start saying, well, maybe giving the law into the hand of private parties is not such a bad idea. So we're obviously up against a certain amount of a stick in the background here to show that we can do this properly and in a timely manner. Thank you very much.